Hello, everyone, and welcome to our webinar. My name is Elena Ortega-Tauler, and I am delighted to have you join us today. Before we dive in, let me share a little bit about myself. I am the founder of Legacy Trust Counsel law firm and an estate planning attorney, serving clients from our base office in Miami, Florida. After graduating from the University of Miami Law School over 25 years ago, my firm has helped thousands of people protect their homes, their assets, and their loved ones. After many years in the litigation field, I recognized the critical need for families to safeguard their assets, their loved ones, in case of an unexpected event. After many years in the litigation field, I recognized the crucial need for families to safeguard their assets and their loved ones in case of unexpected events while making sure that their wishes were honored. This realization fueled my passion for estate planning. My dedication in this field has been acknowledged through feature in major media, major news media, and I'm honored to have been recognized as Legacy Trust Counsel being the City of Doral's best estate planning law firm in 2023. My greatest accomplishment, I feel, however, is raising my 5 wonderful children, 3 of whom are also part of our law firm. As we navigate through life, it is essential to consider what will happen to our assets and our loved ones when we're no longer here. Estate planning is a critical process that ensures that your wishes are honored and your family is taken care of. Today, we will explore the ins and outs of estate planning, its importance, and how you can get started. What is estate planning? So what exactly is estate planning? Estate planning involves making arrangements for the management and disposal of your assets after your death or incapacitation. It's not just about creating a will. It encompasses a range of legal documents and legal strategies designed to ensure your assets are protected, maximized, and distributed according to your wishes, and to minimize potential legal and financial complications for your loved ones. Estate planning is essential because it provides a clear set of instructions on how your assets should be handled. Who will take care of your minor children? And who will make decisions on your behalf if you become unable to do so without the need for a court intervention? Without an estate plan, your family could face a lengthy and costly legal battle, and your assets might not be distributed as you intended. Also, a judge, and not you, might be making your health care decisions and your life and death decisions. There are different types of estate planning documents to accomplish this. There are several key documents involved in estate planning, each serving a unique purpose. Let's take a closer look at some of them. Wills. A will is perhaps the most well-known estate planning document. It is a legal document that outlines how your assets will be distributed after your death. In your will, you can specify who will receive your property, money, and personal belongings. Additionally, if you have minor children, you can designate someone you trust as guardians for your children. It is important, however, to note that a will only takes effect after your death and must go through the probate process, where a court validates the will and oversees the distribution of the assets. This is also the time when a will can be challenged. Conflicts can arise between family members and heirs, and the judge makes the final decisions. Trust. Trusts are arrangements that allow a third party, a trustee, to manage your assets on behalf of your beneficiaries. Trusts can be incredibly versatile and offer several benefits. For example, a revocable living trust allows you to retain control of your assets during your lifetime and make changes as needed. After your death, the trust assets, your stuff, can be distributed privately by your successor trustee without going through the probate process, which can save a lot of time and money. It is also a way to assure that your heirs or beneficiaries receive your assets with bulletproof asset protection against third parties, like an ex-spouse, a lawsuit, or a bankruptcy. An irrevocable trust, on the other hand, cannot be changed once established. It can provide tax benefits when needed and protection from creditors. Trust can also be used for specific purposes, such as providing for a special needs person, a child, or a loved one, or managing assets for a minor child until they reach an age of majority. Powers of attorney. Powers of attorney are legal documents that allow you to appoint someone to make decisions on your behalf if you become incapacitated. There are two main types of powers of attorney: financial powers of attorney and healthcare powers of attorney. A financial power of attorney gives your appointed agent the authority to manage your financial affairs, such as paying bills, managing investments, and handling property transactions. A healthcare power of attorney, also known as a medical power of attorney, allows your agent to make medical decisions for you if you're unable to do so. Having these documents in place ensures that your financial and healthcare needs are managed according to your wishes, even if you cannot communicate them yourself. Living wills and healthcare directives. A living will, also known as an advanced healthcare directive, is a document that expresses your wishes regarding medical treatment if you're unable to communicate them yourself. It can specify the types of medical care you do or do not want to receive and under what conditions, such as life-sustaining treatments, resuscitation, and pain management. A living will provides guidance to your health care providers and loved ones, ensuring that your medical care aligns with your values and your preferences. It's important to discuss your wishes with your family and healthcare providers and provide them with copies of your living will. Why do you need estate planning? Now, you might be wondering, why do you need estate planning? Estate planning is crucial for several reasons. Protection of beneficiaries. Estate planning ensures that your assets go to the right people in the right way. Whether you want to provide for your spouse, children, or other loved ones, a well-crafted estate plan makes sure your wishes are honored. Without an estate plan, your assets might be distributed according to state law, which may not align with your desires and may not provide asset protection to your beneficiaries from third parties, such as the next spouse, a lawsuit, etc. Additionally, estate planning can protect vulnerable beneficiaries, such as minors or individuals with special needs. This is done by establishing trusts or other mechanisms to manage their inheritance responsibly. Minimizing taxes. A proper estate plan can help reduce the tax burden on your estate. By using various strategies and tools, you can minimize estate and inheritance taxes, preserving more of your assets for your beneficiaries. For example, gifting assets during your lifetime, establishing trusts, and taking advantage of tax exemptions and deductions can significantly reduce the amount of taxes owed and avoid capital gains taxes. An estate planning attorney can help you navigate the complex tax laws and develop a plan that maximizes tax efficiency. Avoiding probate. Estate planning can simplify the transfer of assets and help avoid the public, lengthy, and expensive probate process. Probate is a legal process of validating a will and distributing assets, and it can be time consuming and costly for your family. By using tools such as trusts, you can ensure that your assets pass directly to your beneficiaries without going through probate court process. This can save your family time, money, and stress, and going through an already difficult time in court. Guardianship for minors. If you have minor children, estate planning allows you to designate who will take care of them if something happens to you. This ensures that your children are cared for by someone you trust, providing stability, security in a difficult time. Without a designated guardian, the court will appoint someone to care for your children, and this person may not align with your values and your preferences. By naming a guardian in your will, you can have the peace of mind of knowing that your children will be taken care of in the short term and in the long term if something happens to you. Estate planning for everyone. Many people think that estate planning is only for the wealthy. But the truth is, it's essential for everyone. Whether you have a large estate, a modest estate, or very little, having an estate plan in place ensures your wishes are honored, that they're known, and that they're respected. It also provides you with a peace of mind of knowing that your loved ones will be taken care of, no matter the size of your estate and no matter what the future brings. Estate planning is not just about money. It's about making important decisions and providing clear instructions for your family. It's really about the people that you love most. It ensures also that your wishes are carried out, that your loved ones are protected, and the potential conflicts are minimized. For example, if you have specific wishes about how your assets should be distributed, who should care for your children, or how your medical treatment should be handled, an estate plan allows you to communicate all these wishes clearly. This can prevent misunderstandings, disagreements among family members, providing clarity and reducing stress during a difficult emotional time. Additionally, estate planning can address a variety of unique situations. For example, if you own a business, an estate plan can outline how the business will be managed or transferred after your death. If you have a blended family, an estate plan can ensure that both your current spouse and children from a previous relationship are provided for. If you have an intention for charity, an estate plan can include provisions for donations and to provide for causes that are important to you. By tailoring your estate plan to your specific circumstances, you can ensure that your unique needs and goals are met. How do you get started with an estate plan? Getting started with estate planning may seem daunting, but it doesn't have to be. Here are some steps to help you begin the process. Inventory your assets. The first step we do with our clients is to make a list of their assets, a spreadsheet of their assets. This includes property, investments, bank accounts, personal belongings, and any other valuable items. Knowing what they have will help guide us and help guide our clients to make informed decisions about how to protect and distribute their assets to their heirs. It's also important to consider any liabilities, such as mortgages, loans, and debts. We believe that creating a comprehensive inventory of your assets and liabilities provides a clear picture of your financial situation and helps you plan accordingly. And we do this with our clients every day. Consider your family's needs. Think about what your family will need after you're gone. This includes financial support, guardianship for minor children, and any specific wishes you have for their care and well being. Consider factors such as your family's living expenses, education costs, medical needs. By understanding your family's needs, we can create an estate plan that provides for their financial security and ensures their continued well being. It's also important to have an open discussion with your family about your estate plan so they understand your wishes and reasoning behind your decisions. Having access and open communication with your family between your family and the estate planning attorneys will ensure that your plan will work as you want when you need it. Choosing your beneficiaries. Decide who needs your protection, who will inherit your assets. This can include family members, friends, or charities. Be sure to specify how you want your assets to be divided among your beneficiaries. For example, you may want to leave specific assets to certain individuals or allocate a percentage of your estate to different beneficiaries. It's also important to consider contingent beneficiaries. Who will inherit your assets if your primary beneficiaries are unable to do so in the future? Also, you may have something such as a home or a farm that you don't want sold, but you want instead to pass down to your descendants, future generations, keeping your beneficiary designations up to date, especially after major life events such as marriages, a divorce, or a health crisis, a birth of a child, ensures that your estate plan reflects your current wishes. Select a trusted person to be your successor trustee or executor. Appoint someone you trust to manage your assets when you're not able to do so. Select a successor trustee or executor to take on the responsibility for managing your estate, ensuring your wishes are carried out in handling any legal and financial matters that arise, and to transfer your property to your heirs according to your instructions. Choosing an executor or a successor trustee is a significant decision, as this person will have a range of responsibilities, including paying debts and taxes, distributing assets, and managing any disputes that may arise. It's important to select someone who is trustworthy, um, someone organized and capable of handling their tasks. You should also discuss your decisions with the person you choose to ensure they are willing and able to take on the role, and they also have access to the estate planning attorney. Consult with an estate planning attorney. Finally, working closely with a professional to create a comprehensive plan tailored to your needs is so important. An estate planning attorney can help you draft the necessary documents, provide legal advice, and ensure that your plan complies with the state law. An estate planning attorney can also help you understand the implications of different estate planning strategies and recommend the best options for your situation. By working with an experienced attorney, you can have confidence that your estate plan is thorough, legally sound, and aligned with your goals. In conclusion, no matter how much money you have, estate planning is a vital step in ensuring that your wishes are honored and your loved ones are protected. It provides peace of mind and clarity in what can be a challenging time for your family. Don't leave your loved ones in limbo. Take the necessary steps to plan your estate today. Thank you for joining us today. If you have any questions or need assistance with your estate planning, please don't hesitate to reach out to us at Legacy Trust Counsel Law Firm. Our team of experienced attorneys and staff are here to help you every step of the way. Visit our website at legacytrustcounsel.com. Call us at 305-514-0608 or email us at office@legacytrustcounsel.com to schedule a complimentary 15-minute consultation. I will put all this information down below in the comments, so please start planning your estate today and secure your family's future once and for all.